Hello, everyone. Welcome back to the QX Financial playlist series on estate planning. My name is Nathan Bigley, financial professional, and today we are joined by a very special guest, Phil Shekerlian, estate planning professional. Welcome,
Thanks for
Phil.
having me again, Nathan.
Absolutely. Looking forward to it. Today, we're going to dive into the different types of irrevocable trusts, some things you can do with them, including asset protection, and some other things, including Medi-Cal, Medicaid protection, that will be very interesting for the audience. Please remember to like, comment, and share this video if you get some knowledge from it, and subscribe to the channel so that you can stay up to date on all our latest content aimed at providing you with financial wealth and wisdom. So Phil, how are you doing today?
I am doing well. Ready for another day of filming and some education.
Absolutely. It's been a ton of fun. I'm glad we get to keep doing these videos, and you're just full of knowledge in this area, and I've learned a lot already and excited to learn a little bit more today.
Excellent. So today I wanted to talk about irrevocable trusts. I had mentioned before that there are revocable living trusts that are part of an estate plan. Well, another type of trust is this irrevocable trust. This type of trust has a new taxpayer ID number, and it is not necessarily considered an extension of you like a revocable living trust is. Now, back in the day, as the name states, these used to be irrevocable, but in the last 20 or so years, they become less and less irrevocable because attorneys like myself find loopholes. So we have discovered ways to actually change the terms of this trust, sometimes minimally, sometimes significantly, or even delete a trust and create a new trust instead. So I want to talk about that today. One of the ways that an irrevocable trust can be changed is through a process called decanting. If you think about like wine, you pour it from a bottle into another jar called a decanter. So this would be similar, where you take assets out of one trust and you pour them into another trust that has different terms. That process is called decanting. It is usually regulated by state law, not always. Some states specifically allow it, some states specifically prohibit it. Other states are just silent on the matter. If you think that you are in a state that you cannot decant, most trusts allow for a change of governance of the trust. And so, for instance, if the trustee moves from California to Arizona, then that trust is now becoming an Arizona trust. So the trusts allow that to happen. Well, you could simply move that trust to another state that does allow decanting and then do the decanting through that state. And then if you wanted to bring it back into the original state after the decanting is done, you can bring the new trust into the original state.
Okay.
Yeah, it's a handy trick to do.
Right.
Like I said, some of them will allow for a change in terms of the trust. Some of them just the distribution terms. Some of them who pays the taxes, whether or not it's included in the creator of the trust estate for estate tax purposes. You may or may not be able to change the trustee discretion. A lot of the times you can't change the beneficiaries to anybody you want, but you may be able to change the beneficiaries among a certain class of individuals. So for instance, if the beneficiary, let's say I set up a trust and the beneficiaries are my kids, but I decided that my kids were spoiled, entitled, and no longer deserve the money, and I prefer to leave it to my siblings, then I could write a trust so that it says that the person that has the ability to change the beneficiaries can change between a class of individuals consisting of the issue of my grandparents. And so the issue of my grandparents would be my parents, my siblings, my uncles, aunts, cousins, kids, nieces and nephews, all of those people. So I could choose between that whole class. So that's something that may or may not be changed as well, just depending on the state you're in and how the original trust is written.
Right.
Yeah, sometimes you can lower the amount of taxes owed, and sometimes you can change the trustee compensation. But once again, it depends on the state you're in and what their decanting laws are. And also what the terms of the original trust say as well. The process to decant a trust can be quite difficult because it's a loophole. Technically, there's a lot of processes that need to be followed to the T. Otherwise, you can get in trouble and the decanting may not be valid. They're not always the same process, but some of the most common processes are it's the trustee is the one that has to make the changes. It's not the creator of the trust, it's not the beneficiaries, it's the trustee that has to decant. Sometimes that trustee will have to seek court approval, sometimes they won't. Sometimes they will have to get beneficiary approval. If they don't need court approval, they may need beneficiary approval instead, or they may need no approval. The trustee has to give out proper notice to all of the parties. Sometimes that includes different government agencies. If a trust gives any gift, whether it's a current gift or a contingent gift to a charity, then the attorney general of that state that the charity resides in needs to be notified so that the attorney general can represent the charity's interests, and they have an opportunity to contest it if they want.
Interesting. So this is one of those things that you do not want to try at home, I'm assuming.
Absolutely. This is a really difficult one. And you really want to make sure you go with somebody that's done a decanting process before. You don't want to take the chance that somebody new screws something up along the lines.
Right. And I imagine this requires you as the estate planning attorney to be somewhat well versed in the laws in whatever state someone's trying to do this in. I imagine you've spent some time looking at the laws in almost every state, probably, right?
Absolutely, yeah. You need to, if you move the trust to another state, you need to know the decanting laws of that state very well.
Wow, that's very interesting.
Yep. And then the last thing is that the decanting process, the trustee has to give an explanation of the reasons for the change and also the changes that were made to all of the interested parties. You can't decant just because you don't like a trust anymore.
Right.
You need to have a reason to do so. There's limitations on what the reasons are, but really, if you get creative enough, you can decant for almost anything, but you got to be creative about the reasons you're doing it.
Right. You can't just say, I want to pay less taxes, so I'm just going to go ahead and move my trust.
Absolutely, 100%. You were picking up what I was laying down there. So another way to change an irrevocable trust is through judicial modification. So with decanting, you would just need court approval for the decanting. But with judicial modification, you are actually petitioning the court to, one, to allow the changes, and to two, order the changes to be made. If you can show the court that there is good cause to make these changes, which would be the original purpose of the trust isn't being met, or for whatever reason the assets are going to waste, or the beneficiaries can benefit more from another approach, or something along those lines, and that it's in the best interest of justice to make that change, then the court will order it. And so that's the second way that a irrevocable trust can be changed.
And that's why it's important to speak to somebody before you make your trust, so that you have an outlined purpose of the trust before it's put in. If you maybe just do it on your own or find some forms online, I imagine the purpose of the trust isn't outlined so well, so that if you need to make changes in the future, it becomes that much harder.
Absolutely. Yeah.
Right.
And there's different ways to change an irrevocable trust. Some of those ways, which I'll get into in my last two ways we'll talk about here, is built into the trust already. So you can build an irrevocable trust with provisions to allow it to be changed in the future. So you really want to sit down with somebody before the trust is drafted to see, hey, is this something that I want to make an easy option, or am I going to have to go through a more difficult option like decanting or judicial modification? And then another way to change an irrevocable trust is sometimes just the parties consent to changing it. So you can have the creators of the trust, the trustees, and all the beneficiaries. And if they all agree that there's something that needs to be changed about a trust or discontinued, then they can all agree and make those changes. You have to be careful when doing that that's not going to have a significant effect on taxes or some outside entity or agency, because then they will come back in the future and avoid that change as well. So you really need to make sure that all the interested parties are a part of that change.
Right. Like a group decision, almost like a board decision where everyone has to agree.
Definitely. And everyone who potentially has an interest.
Right.
But a lot of the times that's not the case. A lot of times the creators have passed away, or like I said, there may be the IRS or a charity that has an interest in the trust, and you're not going to get them to agree to that. So party modification is only in limited circumstances. The next two ways are the ones that can be built into the trust when it's first created. So if you create an irrevocable trust and you put something in called general power of appointment, the person or individual or entity that has general power of appointment can actually say where the benefits from that trust go to and shift it from one individual to another or entity or whatever the case may be. You have to be very careful when putting that into a trust, though, because putting that in the wrong place could create some significant tax implications. It could actually create some tax benefits as well, but you really need to evaluate whether you want that in the trust, and if so, who is going to have that general power of appointment over the assets.
That's interesting. So it can create a taxable event where there otherwise wouldn't have been one?
Exactly.
Huh.
Absolutely. And then the second way to build in, the fifth way to change a trust, which is the second way to build it into the irrevocable trust, is to put in what's called a trust protector. And a trust protector is an independent party that has no benefit from the trust. They're not a trustee, they're not receiving anything, and they have the ability to change certain provisions of the trust. So those two things can be built in. And once again, with the trust protector, you have to be careful, because if you start giving the trust protector too many powers, they could become a fiduciary. And once they're a fiduciary, they're more like a trustee and no longer a trust protector. And they have to truly be independent with no fiduciary powers to make those changes.
And so if they become a fiduciary, who are they a fiduciary to? Is it the trustee?
To the trust, and through the trust, whoever the beneficiaries of that trust are.
Okay, I
And
see.
that's another argument there, because, well, which beneficiaries do you have a duty to?
Right.
The current beneficiaries, the contingent beneficiaries, and hopefully that's written into the trust, but that's not always the case.
Right. And once that fiduciary standard is put in, kind of the flexibility, I guess, of what the beneficiaries may want starts to get a little bit more narrow, right?
Mm-hmm. Yes.
Hmm.
Yeah. So those are the ways that you can change an irrevocable trust. But let's talk about what types of irrevocable trusts are out there. There's many types of irrevocable trusts, and I have been talking about these quite a lot this week after what looks to be the results of the election. I think everything's going to stay as it is, and challenges aren't going to change. Therefore, there's going to be some significant tax changes. A lot of my clients here in Orange County have they're much wealthier than the typical population of the U.S. And so this is going to affect them significantly in taxes. So I've been working on setting up a lot of irrevocable trusts for these clients I'm starting this week and last week.
Right.
And I got to get these in place by December 31st, but these trusts are going to help them save money in taxes in the long run.
Mm-hmm.
So that's just one type of trust. And we'll discuss those more in general in a later video. There's also irrevocable trust for asset protection. If you're worried about being sued for whatever reason, or you have creditors after you, you don't want to have assets in your name. And by putting them into an irrevocable trust, you can get those out of your name, therefore protecting them from creditors and lawsuits.
Right.
We'll also talk about that in much more detail in a future video. Another type of trust irrevocable trust is to avoid undue influence. Undue influence is when yourself or somebody else is taken advantage of by a caretaker or a loved one. This is quite common these days with Alzheimer's and dementia, because it becomes so prevalent in society, and it's wreaking a lot of havoc with the elderly. Basically, what the most typical scenario that I see is parents have a couple of kids, and the kids grow up to be independent. They have families of their own. They're raising their own kids. They have their careers. They don't have time to take care of a parent full time on a regular basis. When someone has something like Alzheimer's or dementia and it's advanced, they need 24-hour care. There's no stopping that care. And so you want to make sure that somebody can take care of them. Well, if the family can't do it, the kids can't do it because they're busy with their lives, then you have to hire an outside resource. Well, that outside resource can be quite expensive. Part of the planning that I've talked about in the past is making sure you have long-term care insurance, which is sometimes part of life insurance. Sometimes it's an independent vehicle on its own. But if you have that and you can afford to pay for an outside caregiver, then in those circumstances, that caregiver comes in and they spend 24 hours a day with your parents or the individuals that are disabled. And if this happens for a couple of years, those disabled individuals, we'll just call them the parents here, the parents will start thinking, well, why aren't my kids here helping me? Why don't I see them 24 hours a day? This caretaker is here with me 24 hours a day. They must care for me more than my kids do.
Right.
Or I'm going to change my estate and give everything to the caretaker, or give most of it to the caretaker. And that's typically undue influence. So by doing an irrevocable trust before the parents get into that situation, you can make sure that they put what their desires are in stone, and then they can't change that when they get older.
Right. No, it's scary. You hear stories like this in the news or on movies. It almost doesn't sound real, but I'm sure in your experience, you've seen it before, right?
Absolutely. Another way is legacy planning. That's another type of irrevocable trust. Legacy planning allows you to provide for a legacy after you pass away, whether it's to benefit a charity or your favorite school or even your kids or just your community in general. You can make sure that you leave money behind in an irrevocable trust that will provide to those organizations. If you can save enough money during your lifetime, great. You put those assets in the trust, and then when you die, those go to whoever the legacy is. If you can't, then life insurance is a great tool for doing that.
Right.
You can get quite a bit of life insurance for relatively cheap and leave that legacy behind when you pass away.
That's how you get your name on a school, right?
I was just going to say that. Yeah, you could get your name at your favorite college, at a museum, a sponsor on PBS, whatever the case may be. You can get your name out there and leave a legacy behind. And then the next way would be Medi-Cal planning. So Medi-Cal planning it can be a little bit difficult. There are many different programs to get into Medi-Cal. And for those that aren't familiar, Medi-Cal and Medicare are two different things. Medicare is the plan that you get on when I believe you're 65, and that's your insurance that you use. Medicare doesn't cover everything. And if you're not 65, you need to have individual insurance, supplemental insurance. So if you can't afford that, you can get Medi-Cal, which is what it's called here in California. Many other states call it Medicaid. And that is where you don't pay for your medical care. The state pays for all of your care. But then when you pass away, they may come back after your estate to recover all those costs. Additionally, if you have too much money or you make too much money, you don't qualify for Medi-Cal. As far as making too much money, there's a bunch of different programs based on your income level where you can get Medi-Cal. The most important one, and the one that disqualifies most people, is having too many assets. Typically, you can only have $2,000 worth of assets, which includes your bank account, stocks and investments, cash value and life insurance policies, any type of financial investment. You are allowed to have your own car and your own home, but you can't have multiple houses. And anything that's a necessity, you can have what is necessary, but no more. So if you have those items, but you only make, let's say you're on a fixed income and you only make $1,500 a month, that's not enough to live and pay for medical insurance. So if you didn't have those assets, you would qualify for Medi-Cal. So what you can do is you can set up an irrevocable trust at least 5 years before you need to apply for Medi-Cal, transfer those assets into the trust. And once that 5 years goes by, those are no longer considered your assets, and you would qualify to get Medi-Cal. This is a completely legal thing to do. It's not hiding assets. There's nothing illegal about it, but that is one type of trust.
That's a big one too. Medical costs in this country bankrupt a lot of people, especially as we get older. It gets more expensive. That's the time where we don't have that disposable income to pay for a $10,000 hospital bill. So, that's a big one.
Absolutely. So the last type of irrevocable trust, there's many more types, but the last common type of irrevocable trust is what's called a special needs or a supplemental needs trust. These I do quite often. They are very, very useful, and they should be incorporated into every estate plan and revocable living trust as well. And what these do is, if an individual is receiving support from the government, financial support, then inheriting money or having money can disqualify you from that government support. So if you were to, instead of inherit it into your name, you put these assets into a special needs or supplemental needs trust, then you can still qualify for that government support. So the way that it works is that let's say my dad dies and leaves me $1 million. Okay, but for whatever reason, I'm receiving government benefits, government supplemental income. Instead of my dad leaving the $1 million to me in my name and me putting it into my bank account, and then I become disqualified, he writes the check out to my special needs trust. Well, my special needs trust is a different taxpayer ID, and the bank account is under that different taxpayer ID. My name is not on that account. I don't have access to it. There is a trustee of that trust, which is somebody that my dad and I trust, that'll do right by me and use the money for me, and that person's name is on the bank account. Then if I need money for a car, for instance, I can go to this individual, let's say it's my sister, and I go, hey sister, I need a new car. My sister will go out and, well, first my sister will decide whether or not she wants me to have a new car or not, because she has the ultimate authority with a special needs trust, and it's really up to her no matter what. And if she says no, there's nothing I can do about it. But if she says yes, she goes out, goes to Cadillac, buys me a Cadillac CTS-V, puts it in the name of the special needs trust, and hands me the keys and says, have fun driving it. And that's the way that a special needs trust works. The assets never touch my bank account. They never touch my hands. They're not titled in my name, but they're there if I need them. You know, more common is I need clothing or daily supplies or living expenses. If I need my rent paid, she can pay it directly from the special needs trust to my landlord. Things along those lines. But that's how a special needs trust works. And it's really a great benefit for people that are receiving, you know, anything from Medi-Cal, Section 8 housing, state and federal disability, any other types of welfare. It's really a valuable tool. And so many people receiving that type of aid, especially with coronavirus going on, it's really important, like I said, to have that as part of every estate plan. But in some circumstances, it needs to be a standalone special needs trust set up for certain individuals.
Right. No, it sounds like a fantastic tool, and one that's very timely right now, like you said, with COVID going on, and people need those benefits. Just because that trust is there, it doesn't mean that they don't still need some assistance. So
Absolutely.
sounds like a great tool.
Yeah.
Cool. Thank you so much for watching our video today on irrevocable trusts with Phil Shekerlian. As always, we're going to put his information down at the bottom, so feel free to reach out, as he's currently doing free consultations for the viewers of our channel. Tune in next time, where we'll get into the different types of asset protection strategies that you can use with your trusts and what it could mean to you. Thank you for joining us. Please remember to like, comment, and share, and subscribe to the channel so you can always be tuned in to all our new content. The commentary provided in this video is for informational and educational purposes only. No advice, offer, or solicitation of any kind, expressed or implied, is being given. The views and opinions expressed do not necessarily represent the views and opinions of QX Financial, any subsidiaries, or associates thereof. When considering making any changes to your situation, you should consult a competent licensed professional. All rights reserved. Copyright September 17th, 2020.
This information is not intended and should not be taken as legal advice for any particular set of facts or circumstances. You should contact an attorney directly for advice with specific legal problems. None of this information creates an attorney-client relationship with the law offices of Phil Shekerlian.